Well, if you recall, Judge Adama has made repeated references to this mythical ice cream stand, where if I was an owner of the ice cream stand and I'd been personally aggrieved by somebody stealing from my ice cream stand, in his view, I would then have standing. Well, it hadn't occurred to me at the time when he was making that analogy, but when I got home, I remembered that I am the owner of a Port Authority of New York and New Jersey bond, which as a matter of law makes me an owner of that proverbial ice cream stand. He said that I was within the territorial jurisdiction. He said that I was within the statute of limitations and that there was enough evidence to believe that the crime had occurred, but he felt that I was too far removed because I didn't have an interest. Now, as a matter of fact and law, as a matter of contract, as a matter of Securities and Exchange Commission legislation, I am an owner of the Port Authority of New York and New Jersey, which means that I have standing to bring this complaint. Now, I don't want to give anybody the impression that Judge Adames was right in demanding some sort of special connection to the crime. That's not the fact. But rather than get involved with a lengthy appeal, I will just cater to his wishes and show him that I was personally affected as a bondholder who was not made aware of these crimes at the time that I bought my bond. They withheld his sentencing until after the Bridgegate trial, and his sentence was not a day in jail. He's going to spend his sentence on house arrest at the very vacation home he was extorting United Airlines into bringing him to. And that's not justice, because if they can let him do that and keep other people in jail on mandatory minimum terms of imprisonment, then we don't really have a justice system. Well, the reason he got away with what he got away with so far is because there's nobody doing their job in this system. And I'm going to do it for him if they won't do it. The arc of the universe is long, but it bends towards justice.
Best of luck.
Thanks.
Good morning, Your Honor.
Good morning.
If you recall, Your Honor went through the elements that are clearly in the Rule 7.2-2, and that was, is the complaint within the statutory time period? You said it was. You said, is the complaint within the territorial jurisdiction of this municipal court? You said it was. Are the elements of the offense met based upon the evidence before you? You said you were the charge. What you said you were satisfied, but then you said that you read something into the statute, that there was some into the rule. You read into the rule that I would need standing, and you made an analogy to if I was the owner of an ice cream stand and somebody had robbed me. And I wasn't, at the time, you know, because of the case law that I'd cited about standing on any complaint and citizens, I wasn't really prepared to deal with that response. But after I left, it occurred to me, I am the owner of that ice cream stand. I have a bond issued by the Port Authority of New York and New Jersey that I bought without any knowledge that this crime had taken place or was taking place or was being investigated or was subjecting my company, my ice cream stand, to a fine. Now, as a matter of law, evidence that I am a bondholder of the Port Authority of New York and New Jersey confers upon me direct standing to any crime that occurs from any board of director or any management agent from who's an official appointed by the state of New Jersey in that matter. So I'm back, Your Honor, and I'm here to satisfy that connection that you didn't see had been made in the earlier proceeding. And I swear under penalty of perjury that I purchased this bond before these charges were leveled, before they became public, and I had no knowledge that David Samson was involved in extortion and bribery when I bought this bond. And because of that, I am injured.
When we came here together last, and you may mention just now that I read into the rule.
Yes.
There's a rule at the beginning of the rules that says that these rules going forward can be relaxed. Before we can even discuss it, I want to make sure we're on the same page.
Okay.
Right?
Just before I open this, before I read this, I want, you know,
Read it to yourself while I read this.
Okay, so this rule militates towards processing this complaint, because what you had before you was sworn evidence that was unrebutted that the man was guilty of a serious crime. So this rule would militate towards the interest of justice and consistent with management case trial guidelines of processing this complaint. If he had
That's your position. Okay. That's your position. Certainly my position at the time that we were together last, it's different. And so, what you were arguing at the time was that this is the rule, and you meet the criteria, and then it should be met.
But that has been the practice in the state of New Jersey for the past 30 years.
So there's a rule that comes before all the other rules that allows for all of these rules right here to be relaxed. It's a big book.
In the interest of justice. In the interest of justice.
So what I told you at that particular time was that your position was so far stretched away. Now, what other judges may have decided in the past is fair. That's their decision. And so we all interpret the rules and the laws, statute, case law, what have you, differently at times. And that's why there's opportunity for other venues to appeal and to, so this happens all the time. There's matters that are overturned all the time. But I've been given the opportunity to study the rules and to use that particular rule when I see fit.
And I also want to mention that I am the owner of United Airlines stock, and I was the last time I appeared before you. So as a Port Authority bondholder and United Airlines stockholder, where United Airlines had to pay millions in fines, the Port Authority had to pay millions in fines, the Port Authority had to pay legal counsel to represent the agency in an SEC investigation, in a Southern District in a District of New Jersey federal investigation, in an investigation by the Southern District of New York and the Manhattan District Attorney. The value of my bond was diminished as a result of the crimes of this man. I am, as a matter of law, undeniably affected by this particular crime. And the date on the bond precedes the date of the crime being made public. I was not made aware that this was all going on and going to go on with my corporate funds at the time that I bought the bond. In April of 2014, and they didn't make this charge public until July of 2016, which means during the time that I owned this bond, my bond was being used to present the defense to 3 different agencies, and 4 if you add the Security and Exchange Commission, and I had a right to know that I was buying a bond in a company that was under investigation. I was aggrieved. Now, I have the right, if I choose to go to the Securities and Exchange Commission. I have standing to file what's called a derivative suit as a shareholder of the Port Authority. So certainly, if I have standing to file a derivative suit as a shareholder of the Port Authority, I have standing to file a criminal complaint against the chairman of the board of my ice cream stand, because you used that very example repeatedly. If you own the ice cream stand, I could see the connection. Here's my ownership of the ice cream stand, Judge. This is your analysis.
So everyone, just to be clear, everyone has the right to file. We talked about this last time. Everyone has the right to file a complaint. Everyone doesn't have the right to seek the individual that's named as a defendant prosecuted. That's not right. That's not right.
Look, the rule that we're talking about says you shall issue probable cause under certain circumstances. Doesn't say you may, doesn't say you should, doesn't say you might. It says shall.
And the rule that I pointed out gives me the opportunity to relax all of these.
Only in the interest of justice. Only in the interest of justice. And how are you saying that this justice is being served by letting this man go free?
He didn't go free. He didn't go free. You, listen to this. You wanted him to be incarcerated.
I wanted him to be charged under state law.
No, listen. You told me you wanted him to be incarcerated.
For 5 years.
You told me if he had gotten jail time, prison time, on the federal side, he wouldn't even be.
And my motive is not relevant, Your Honor. My motive is not relevant. I am aggrieved.
You just told me that you wanted to see justice happen. He's already been prosecuted.
Not under state law crimes.
He has been prosecuted. We can agree upon that.
It's not up to you to do that.
He has been prosecuted. He has been prosecuted.
Not under the federal, not under state law.
But not to your liking.
No, not under, I live in the state of New Jersey. I'm a resident of the state of New Jersey and a citizen of the state of New Jersey, and you are turning my residency and my citizenship around. I have a civic duty to report crimes and see that they're prosecuted. If the prosecutor decides that it's not in the interest of justice, he will make a motion to that effect and support his motion. But right now, what's before you are the 3 criteria that are consent in the rule, and we're talking about a man who has admitted his guilt. It is not for you to decide that he shouldn't be prosecuted. It is for you to decide whether probable cause exists and not read into the statute something that you don't like about me. I'm telling you
Are you telling me
that,
that I can roll up or that I have discretion?
I'm telling you, you have no discretion where the elements are met.
You're telling me I have absolutely no discretion as a judge. And that rule right there that I mentioned to you, that you read, you're saying to me it's not applicable and it doesn't apply.
I'm saying exactly that is a rule. The rules of statutory construction, wait, if I may argue for a record, because this is going to be, I can tell where you're going, Judge. And I can tell you where.
I can tell where you're going.
Okay, we're going all the way with this, because what's happening here, you know what, I've been in court more times than the defendant for this particular crime. He showed up twice, the day he pled guilty and the day he got sentenced. This is not justice, Your Honor. This is something other than justice. This is a rich, powerful white guy getting over on the system, and I'm not having it. So you want to go along with it, that's on you. But I'm telling you right now, the rules of statutory construction require you, in the interest of justice, to see that the guilty people are charged. It is not your position as a municipal court judge determining probable cause to go beyond that determination. Here and now, it is up to you not to protect this man in any way from what you think may be my motive. It is your job to decide one issue. The one question before you, the one and only question for this court today, here and now, is probable cause, does it exist? And you said so on the record last time. You said territory, time, and elements of the offense have been established by the competent evidence. I have a tape recording of you saying that. You then said you're reading into the record, into the rule, some requirement that I have a firmer connection. Okay, I'm Johnny on the spot with a firmer connection. I'm a bondholder in the ice cream stand that you brought up. But now you're going to try and do something different, and it's entirely inappropriate. I don't know what the motive is, but it certainly is in the interest of justice what's going on here. The man is not being brought to justice, and if somebody down the road, your question isn't for you to decide whether or not my motive is pure, whether or not I have any more of a connection than you said I needed, but you told me I needed a different connection. I came back. You said there's this hoop that you need to jump through. I just jumped through it. Now you're taking out another hoop. And that's inappropriate, Your Honor. That is completely inappropriate.
Sir, I've been charged to take this position, as difficult as it may seem to many people out there.
This one particular.
I let you talk. I let you speak. I stayed quiet, and I let you speak and say what you had to say. Please give me the same opportunity. Now, I have absolutely no connection with this person. I don't know what if he came in here, I would think I know what he looks like. I don't know him. I don't care about him. I've never shaken his hand. I don't know a thing about the man other than what's been reported and what I've seen. Now, has he done a terrible thing? Certainly. It's clear. Did I talk about his reputation going forward? Yes, I talked about those things. I have no particular motive except to protect the process. If you don't like it, that's fine. If Mr. Genova, Mr. Samson doesn't like it, that's fine as well. And I'll suffer the consequence for any decision that I make that I believe is appropriate and that's right. And I tell you, in my position, I don't believe at all that I'm in a box that I must and require, based on the rules I think mentioned, do exactly what you want me to do. I can take your complaint. I don't have to find probable cause because that's what you want me to do.
No, I want you to find probable cause because I've established it. That's the difference between what's going on here. I established probable cause. I established probable cause in your courtroom. What you're doing is something extrajudicial. Something extrajudicial is happening right here on this tape. I have established probable cause. I have met every one of the criteria that's in the rule, and then I met one that you created, and now you're creating another one.
Mr. Brennan, probable cause is denied. Go off the record.
You're not going to give us a reason why?
Mr. Brennan, I'm off the record.
No, you haven't. Listen, you have been disrespectful to the court, completely disrespectful. Listen to me. Here you are again. I speak, and listen to me, Mr. Brennan. This is theatrics. This is not appropriate. I believe you to be a gentleman, and I've tried to treat you as a gentleman. But you've been nothing but disrespectful in this time. Because you haven't gotten the desire that you wish to have.
Because you're not doing your job.
And you are again. Yelling over me. That's not appropriate. That's not appropriate. That's not appropriate at all.
I confess to contempt.
That's not appropriate at all. For the reasons I mentioned before, that you lack standing, and even in this instance, You indicate that you bought this bond right here in 2014, but the incident date that you've mentioned here is 3 years before. So for all of those reasons, it's denied. No standing.
You put that in 60.
Well, again, as I started to say, this is Jersey justice. The judge took it upon himself to do something extrajudicial. His function here is to determine three things: the criteria that exist for probable cause. What he's reading is a general rule that says in the interest of justice, he may relax some rules. He didn't cite a rule that he relaxed. He added a rule. And that's not his function, to create standing as a impediment or a predicate to having a citizen file a complaint. The only issue before this judge was, does probable cause exist? He didn't reach that rule. He is supposed to do that job. So I am now going to file what's called an action in lieu of prerogative writ to force him to make the determination as to whether or not probable cause exists, not to determine whether I have standing, because standing is not in his purview. And even if it were, the document that I produced today confers upon me standing in all matters involving the Port Authority for any crime that occurred before July 14th of 2016, when the information was made public and the deal was made. This stuff was being concealed from the public at the time I bought my bonds. This judge isn't fit to preside over the food court at your local mall, let alone make decisions of this magnitude. And in my view, somebody got to him. Either he took a payoff, he's been given a job, or some other fashion. And in my opinion, this is not a decision based on the law, based upon sound legal reasoning. This is based upon Jersey corruption, pure and simple. I was deceived by David Samson and the Port Authority of New York and New Jersey and the U.S. Attorney's Office by concealing these facts. And this is all done to protect Chris Christie. Yes, I'm taking this judge to the Advisory Committee on Judicial Conduct because he is acting outside the scope of his authority as a judge. He had one job today, and he refused to do it. So I'm going to make him do his job. You know, sometimes these things unfold the way they do for a reason. And as many people have to go down to protect this man as necessary will. This man is going to go down for what he did. He's not fit to serve as a judge, and I'm going to see that he doesn't serve as a judge any longer.
Are there any other avenues you're going to take with Samson?
Well, I'm going to make this judge find probable cause, or a legitimate judge find probable cause on David Samson, and then we'll see what the prosecutors take their turn at trying to protect this man. But keep in mind, he committed an act of extortion to the tune of millions of dollars, and he used his official position to do it, and he's not going to serve any jail time. There are people in jail today for having crack cocaine in their possession in the 1980s who are serving mandatory minimum jail terms. What is the greater harm? Somebody possessing crack cocaine, or somebody shaking down an airline using his official position as the chairman of the board of the Port Authority of New York and New Jersey to coerce people into engaging in activity that they didn't otherwise want to engage in? One person hurt himself. This person hurt millions.